And we are going to go ahead and start with our legal research part 1 installment of our back to school legal research series. So just as a brief recap, if you don't remember, my name is Andrea Valencia. I'm the reference and instruction librarian here at the Riverside County Law Library. And with me, I have Jenna Pontius, the public services librarian. She can wave right now if she wants. And our emails are on these slides as well. The slides will be available to you following the session as well as the recording. So just to give everyone a brief idea of where we're at. So we are on our 4th installment of this series, Legal Research Part 1. In this session, we're going to be discussing the basics of legal research that cover primary versus secondary authority, things like that. And then our final installment will be next Wednesday, September 29th. It's going to be our part 2 of legal research, where we're going to be doing a live demo of answering a reference question. So one of you kindly sent to me a reference question that you would like me to answer live. We already went through it together, and they gave permission to be able to go over that process in next week's class. If you have a question that you would like to submit, you may submit it to my email or the law library email, and I'll type it in the chat later. And then you could just give me the brief overview of what you're looking for, and we can do that together. So let's go ahead and get started with legal research part 1. This is going to be just a very basic overview. There's a lot to it, and hopefully this will give you a basic understanding and help with your legal research in your own life. So just to get everyone's idea of where we're at. So if you recall back in high school, we had these concepts such as primary and secondary sources. So as using the Declaration of Independence as an example, would we say that this is a primary or a secondary source? You can go ahead and type it in the chat. So yes, it's a primary source. Thank you. So primary, if you remember, means it was, an original document written at the time from the person itself versus a book about the Declaration of Independence published recently, right? Published in 2008. That would be a secondary source. The secondary source usually talks about the primary source in a different perspective, right? So the same concept applies to law. There are primary and secondary authorities associated with legal research. The first that we're going to go over is primary authority. So primary authority is law that's generated by a government body, or their cases decided by a court that would be considered primary authority. So some good examples of this would be statutes or codes passed by the legislator. The California Constitution itself is a primary authority, regulations issued by state agencies, case law, California Rules of Court, things like that. So these are all original, codes, documents, and things like that. So 2 things to note about primary authority is that primary authority can be either mandatory or persuasive. So before we get into mandatory authority, just a quick review of the California court system. There's basically 3 levels, starting with county superior court, then the Court of Appeals, and then the California Supreme Court. So how mandatory authority works is from the top down. Once something is passed by a higher court, it's binding on all lower courts, whereas persuasive is not. So to start with mandatory authority, so mandatory authority, like I said, it refers to cases, statutes, or regulations that the court must follow because it is binding on the court. meaning that lower courts are required to follow decisions from higher courts in the same jurisdiction. Now, persuasive authority means that the court has the option to follow it, but does not have to. For example, the California State Court is not required to follow a decision of a Nevada State Court, but a Nevada judge may have used a line of reasoning in deciding a case that California judge might find helpful. Persuasive authority refers to cases, statutes, regulations, or secondary sources that the court may follow but does not have to follow. Thus, the holding from a court in another jurisdiction or a lower court in the same jurisdiction is persuasive authority. So secondary authority. Secondary authority usually analyzes, comments, etc. on primary authorities. Secondary authority does not have a binding effect on the court, but helps explain what the law is or what it should be. So secondary authorities are all persuasive, and they include things like legal encyclopedias and dictionaries, legal textbooks, treatises or hornbooks, legal periodicals, law review journals, law review articles, annotations published in code or statute books, or legal briefs and memoranda. So here's just a overview again of secondary authority. So there could be something like a textbook, essays, articles, things like that, things that comment on primary authority that you can use as a greater understanding, but are not considered mandatory or binding. So when would you use a secondary source? So oftentimes when we do reference requests, we may include a secondary source, and that's just to give like a general understanding or a brief overview of the legal topic in discussion. So they're used to explain the law or a particular legal concept. It provides insight into a legal topic by discussing the more important relevant cases and by explaining how that law is applied to the facts. A researcher uses secondary authority to gain insight into a legal topic, as well as also to obtain citations to primary sources. So that's a good point to make in legal research. If you're starting out with a secondary source, that can help you with your legal research by leading you to relevant primary sources. So here's an example of a legal periodical. So if you didn't know, the Riverside County Bar Association releases lawyer magazines every other month. So this would be considered a legal periodical and a secondary source because they have articles and things like that within the magazine. Another example of a major index for legal periodicals is Hein Online. Hein Online is a database that we have access to here at the Law Library. It's one of my favorite for secondary sources because it has lots of peer-reviewed articles and things like that. And then some other periodicals include Google Scholar, Legal Track, things like that. Something that we get a lot here at the Law Library is requests for hornbooks. So a hornbook will give you an overview of the relevant cases, regulations, and statutes for any area of law. So something important, a tip for hornbooks is don't forget to check the hornbooks table of cases/statutes for citations to primary authority. So as I said earlier, sometimes it's really helpful to start with a secondary authority to get a general idea of what we're looking for, and also because it has direct citations to primary authority. Another secondary source would be legal encyclopedias, which are very helpful. So like hornbooks, legal encyclopedias like CJS and Amjuror Second will provide useful background and inform the researcher of major cases that acquaint the reader with useful terminology. So state-based encyclopedias have the advantage of focusing on law in a particular jurisdiction. And then also there's American Law Reports, or ALR. That's what they look like right there. ALR is a collection of well-annotated subjects. While not all legal issues are included, an on-point annotation can be very helpful by pointing you to multiple relevant cases. So West Publishing has put out many editions of ALR, the 5th series, and the most up-to-date is significantly different from the ALR 4th edition. And also ALR federal only includes federal cases, so that's something to note. So now we're going to move on. Now that we've covered all of our sources and what we can use for our legal research sources, we can go through our legal research tips. So this is where it's not complicated, but it's kind of up to your processing style as well. So for example, I'm a very visual person. I like to have all my tabs open and go in between them. I like to also write down exactly like what I'm searching for, maybe brainstorm some synonyms and keywords before I just start Googling things. So something to start questioning is what are the facts? Gather the key facts and write everything down. Next, you're going to determine what is the legal issue. So that often comes into my thought process when we receive reference requests here at the law library, because it's hard to determine what the legal issue is in the middle of a long story. So part of kind of navigating that is to take the story and then kind of bring up, you know, what is the legal issue here? Is it this or is it this? You know, is the problem really the eviction or is it the money associated with it? So things like that will help us determine what we're searching for. And then lastly, what is the jurisdiction? So this is something that's incredibly important for me because when we receive reference requests for questions where sometimes the forms are different per the jurisdiction. So for example, civil versus family law versus criminal may have the same title of a form, but they're different because of the different jurisdictions. So that's important to know when we receive questions for forms. Next, we need to find primary sources of law to support our legal argument. So we need to find the relevant state codes, state municipal codes. We need to find maybe law review journals or legal articles that can help us, you know, get some more like clear diction regarding the law, just because sometimes it's hard to read it and it's so complicated. So getting something simplified via a law article is really helpful. And then lastly, we need to determine that the sources that we're using are good law. So we're going to be going over Lexis and Westlaw and their Keysight citations later in this presentation to kind of give you the idea of what you should be looking for in regards to good law. Good law is law that's hasn't been overruled, hasn't been dismissed, reversed, questioned, things like that. It's still relevant and you can use it in your legal research, in your memoranda to support your argument. A bad law would not support your argument, and it's not something that you should bring up in your argument in front of like a judge, for example. So we're going to start with what are the facts. So when you're presented with a legal research issue, you want to gather the who, what, when, where, and why, and how of your case, and write everything down. Usually in like a brief or a memoranda, you'll have a section for a statement of facts, and that's just going to go over very briefly like what is going on, who is involved, what is going on, things like that. Even if you don't think it's relevant now, it's just important to help write it down so that you have a clear idea of where you're starting. And then what is the actual legal issue? So you don't know what to research if you don't know what the legal issue is. So for example, does the client want to file a small claims or do they want to fight an eviction? Things like that. And no matter the legal research project, you have to identify the legal problem at hand as well as the outcome or relief sought. So this will help guide your research. And then you also want to go over what is the relevant jurisdiction. So don't cast your net too wide, meaning that you need to focus on, for example, if you're focusing on civil limited, you need to narrow it down to civil limited. And also if you are comparing state versus federal law, you need to narrow it down to what state are you referring to. So for example, you may find a case in a California state court that's exactly like yours, may be relevant, but it won't be very helpful if your legal project involves New York law. So something that we get in the law library a lot is people who want case law for California and then relate it to their like Nevada case, for example. So it's not going to work because it's different jurisdictions, obviously. So keyword searching, keywords are commonly called like search terms. So they're the words that you enter into the little database search box, and they represent the main concepts of your research topic and are words that you use in everyday life to describe the topic. So for example, in our everyday life, we may use the words like eviction, landlord, tenant, but the legal terminology may include unlawful detainer, 60-day notice, things like that. So selecting the correct keywords involves a multi-step process where you identify the main concept of your topic, where you brainstorm synonyms and antonyms that could be used, and also spell out any abbreviations. So sometimes when people are searching for like workers' comp information, they don't know that you should, to yield the most results, you should probably spell out workers' compensation versus just leaving it as workers' comp. Because many like sources, like secondary sources, are not going to just limit it to workers' comp. It gives you more results if you compensation. So some synonyms, like I said earlier, if someone has a question about their landlord, you can use the search terms like unlawful detainer or eviction. If someone has a question about their parents' house, so you may use the words property, deed, estate, probate. House is a common word that we use in everyday life. However, legally or in our search terms, we can use these legal terms to yield more results and maybe find what we're looking for. Another research tip is to use Boolean search terms. So this is something that we may have reviewed a long time ago, but we forget often to use it in our legal research, and it comes in handy a lot. So the three Boolean operators are and, or not. And why would we use these? They're helpful to focus a search, particularly when a topic contains multiple search terms, which is very common in legal research. We have multiple search terms, and to connect to various pieces of information to find exactly what we're looking for. So to use and in a search, we would use and to narrow our results. We would tell the database that all search terms must be present in the record. So for example, a patron is asking for cases in California related to suing a car manufacturer for recalling a vehicle regarding a defect. I think I mistyped that, but I did receive this question recently. So there's a lot of things going on in this question. So to yield the most results and get the specific information I'm looking for, I will use car manufacturer and warranty and defect, so that I can see what is yielded and see if there's a possibility of maybe finding cases where there was a successful suit in suing a car manufacturer for a defect within a warranty period. So using or now, where we're connecting two or similar topics or synonyms, this will broaden our search results and tell the database that to ignore concepts that may be implied by the search term. So for the same example, a car manufacturer calling a vehicle regarding a defect, we would do defect, not default, because we want, because default usually refers to like a default judgment. And although that may be useful in our search later to see if anyone did receive a judgment, we want to start at the beginning of our research with just seeing if there's any cases related to the defect at all prior to receiving judgment. Okay, so now we're going to go into the Keysight and Shepard's indicators. So as you can see on the screen here, I have two cases. I think I just searched for First Amendment in school, and I looked this up on our database Lexis. So as you can see, there's a green little indicator on the top case, and then there's a big stop sign on the bottom case. So this is telling me that the first case has positive decisions and it's good law, well, whereas the stop sign is bad law or has negative treatment. So going over the 7 Shepard signals on Lexis, there's the red stop sign, which means negative treatment indicated. It doesn't always mean that it's not good law, but it is negative history, and we want to avoid that generally. There's the red exclamation mark, which means negative case treatment is indicated for the statute. There's the orange square, which is validity questioned by citing references. And we always want to use valid sources. The yellow triangle means caution, possible negative treatment indicated. The green diamond means positive treatment indicated. The blue circle with an A is cited and neutral analysis indicated. And then the blue circle with an I is cited references available. So next we're going to look at Westlaw. So for Westlaw, we see that they use a little flag system. So there's a red flag here and a yellow flag here. So for Westlaw, the red flag is similar to the red stop sign for Lexis. It means that there's negative treatment. Yellow means caution, there's possible negative treatment. Blue strike flag, I think what was that one? I didn't write it down, but the blue flag, I think, is the same thing. It's the cited references available. And then the caution mark is overruling risk alert, means that maybe it's being currently talked about and there's possibility that's going to be overruled. So I did a quick search demonstration. So by searching for the California Constitution and the First Amendment on Google, it took me to the California Legislator website, which brought me to the California Constitution. So if you don't know that states have their own, most states have their own constitution, just like the United States of America does. And so they often reflect the rights from the Bill of Rights in the Constitution, but are maybe worded differently. So, for example, this is the California Constitution referring to freedom of speech. Every person may freely speak, write, and publish his or her sentiments on all subjects, being responsible for abuse of this right. A law may not restrain or abridge the liberty of speech or press. So that is written in Section 2 of our California Constitution. So if I were to search for California Constitution free speech on Lexis, I can find cases where this section of law is referred to. So I just pulled the first positive case that I found, which was Lamar Central Outdoor LLC versus City of Los Angeles. So as you can see, it is green. It has several citing decisions. So once we open it up, you can even see on the bottom, it has the core terms. So those are similar to our key terms. So if you found that this case was relevant to your search, you can brainstorm additional search terms from the core terms listed on the case itself. It also has the ability to Shepardize on the right-hand side. It says Shepardize this document. And what we do when we Shepardize is we basically pull all of the cases where this case is cited. And additionally, it'll give you the parallel citations. So these parallel citations allow you to refer to the same case in every other place that it's located physically or online. So this is where it's located in the Cal Reporter, and this is the citation for Lexis, and the I can't read that. It's the Cal. It's the what's that one? So the last example that I want to share with you is the the usefulness of local municipal codes. So for example, this is really common for maybe just the average public person. So for example, a dream of mine when I was younger was to have a miniature pig. I always wanted one, and every time I would tell people I wanted a miniature pig, their response was, that's probably not even legal to have in your house. You probably can't get it. So I found on the City of Riverside municipal code, if you go to the website and you just search in the search bar for pig under codes, we can go to section 8.19.070 for regulations and click on that, and it'll take us to this chapter for potbelly pigs. So we can see the definition of a pig and the purpose of it. So I'll read it to you. Miniature potbelly pigs are increasing in popularity as domesticated pets, and the keeping of not more than 2 such animals on any single family residentially zoned property, excluding RA5 and RC zones, is permitted in the city. However, such animals are still livestock, notwithstanding size. The keeping of such animal needs to be closely regulated and controlled to ensure that such an animal does not become a nuisance or danger to the general public in the neighborhood in which it is kept. So basically, yes, I can get a pig if I want to. However, the further step for this research would be to look up these RA5 and RC zones, which I did. So you can just Google it, the RA5 and RC zones for City of Riverside. It's the first thing that pops up. And you can see that this is the RA5 and RC zones. And it just gives you just a basic understanding of how big the lot needs to be to qualify under these certain things like that, under these certain zone requirements. But basically I can get the pig and that makes me happy, but I probably won't. So this is the legal research tips recap. So if I can leave you anything following this session, it would be to determine your legal issue. It would be to narrow down your jurisdiction, set expectations that no 2 cases are the same in your legal research, check your sources, and also conduct or consult secondary sources like legal treatises, articles, journals, encyclopedias, and more to get a greater understanding and also get links to primary authority resources as well. So that concludes this week's session. So we're going to open it up to